Good afternoon, Your Honors. To respond to question CB, asking whether the pretrial chamber considered appropriate factors and drew appropriate conclusions about those factors in determining that an investigation would not be in the interests of justice, an assessment I fully join my colleague in arguing is one a pretrial chamber cannot carry out when the prosecutor has found an investigation serves the interest of justice. The answer is clearly no. Beyond this legal conclusion that the factors are inappropriate for the pretrial chamber to consider, I would like to explain why these factors in this situation, and indeed possibly in future cases should the investigation be authorized, I will go through each of them and give our reactions to them, and that is from the perspective of the victim's interests. First, regarding the purported significant time elapsed, the U.S. torture victims certainly would have preferred that the request was filed much sooner than it was. Likewise, they would have preferred not to have waited nearly a year and a half for the pretrial chamber to issue its 30-page decision denying the request to open an investigation. As for the delay being caused to forgo an investigation, I respectfully submit that this issue has been adequately addressed in the briefing by the parties, by the legal representatives for the victims, and by amici's briefing. Successful investigations and prosecutions in which the rights of all parties are respected have been conducted with a far larger time gap than exists with the U.S. torture program. But it is also a mistake to consider that the U.S. torture program is fully over. 40 men who went through the global detention network remained imprisoned today at Guantanamo Bay. My clients, like many others, have never been charged with a crime and so remain in the same indefinite detention they endured on the territory of states parties. For Mr. El-Hajj, that includes 23 months on the territory of Jordan in proxy detention in 2002 and 2003, before being transferred to Afghanistan, where his enforced disappearance continued for 8 months until he was transferred to Guantanamo in August 2004. For Mr. Duran, he was seized by Djiboutian security forces while transiting through Djibouti in 2004, turned over to the CIA, and at some point between March 2004 and September 2006, that information is classified, he was detained and tortured in Afghanistan. Furthermore, my clients and other prisoners are not on the territory of a state party now. While they're not on the territory of a state party now, the severe mental harm, if not also the physical harm, that they endured on the territory of Afghanistan, or Poland, or Lithuania, or Jordan, or Djibouti, as well as other state parties, has been continuous. I pause to note briefly here that contrary to the pretrial chamber's focus on, quote, capture, as somehow separate and apart from torture in its flawed nexus analysis in paragraphs 53 and 54, the capture and abduction, the kidnapping and enforced disappearance are part of the criminal conduct, including torture, not merely antecedents to it. Most fundamentally, however, the gap in time has not eliminated either the need or the yearning for accountability and justice for these victims and for so many others. Regarding state cooperation, the parties have also fully briefed why the pretrial chamber was wrong to speculate about the extent of state cooperation before an investigation was authorized. 3 further points for the chamber to consider. Cooperation from the United States, a non-state party, is not necessary for a successful investigation of U.S. torture. U.S. government reports, including the Senate Torture Report, memoranda, legal memos, and statements by former U.S. officials in the public domain, provide ample investigatory leads, if not evidence. As stated yesterday, the U.S. torture program was global in nature. The sad and disturbing reality is that far too many countries, including dozens of ICC member states, provided assistance to the United States, allowing use of airspace, refueling stations, sharing of intelligence, holding victims in proxy detentions, or hosting secret black sites. We know this in large part because of investigations done by Dick Marty for the Council of Europe, or the 2010 Joint Study on Global Practices in Counterterrorism Operations by former UN Special Rapporteurs Manfred Novak and Martin Scheinin, or through the work of the Open Society Justice Initiative and the Rendition Project. The prosecutor might be starting this investigation late, but she certainly won't be starting at step one. Unlike the United States, member states do have an obligation to cooperate with an ICC investigation, and as a result of their own involvement, are a rich source of information: memos, cables, flight plans, meeting readouts, satellite imagery, just to name a few. And respectfully, I submit most critical for the legitimacy and success of the International Criminal Court: the perception, the widely held perception, that the pretrial chamber foreclosed the investigation because of U.S. bullying, fed in no small part by the timing of the decision after such a long delay, as well as the pretrial chamber's own reference to, quote, the political landscape, or, quote, the political climate, sends a dangerous message that the easiest way to kill an investigation or a case at the ICC is obstruction and threats. The impugned decision stands in stark contrast to the decision by the pretrial chamber considering whether to permit an investigation in Burundi. There, despite the prosecution's assertion that the government of Burundi had, quote, interfered with, intimidated, or harmed victims and witnesses, the pretrial chamber proceeded to authorize the investigation. Regarding the availability of evidence and suspects during the investigative phase, I touched on this part in discussing member states' cooperation briefly. I would only add that the victims of CIA and DoD detention themselves are key sources of potential evidence for the prosecution. Indeed, today's New York Times has sketches newly cleared for release from Abu Zubaydah, one of the CIA detainees, detailing his own torture. As for suspects, and I use that term carefully, many key figures in the U.S. torture program continue to maintain a public presence or even a public role, public official function. It might be surprising for the court to hear that some speak without reservation about their role in the torture program. Such is the reality when impunity reigns. The sworn testimony of some participants in the torture program is also available as a result of proceedings in U.S. courts. For example, the ACLU civil case, Salim v. Mitchell, led to the sworn testimony of CIA contractors James Mitchell and Bruce Jessen, two psychologists contracted by the CIA to design and implement its torture program, as well as that of two former CIA officials, John Rizzo and Jose Rodriguez. Notably, Mitchell and Jessen have been called to testify before the U.S. military commissions at Guantanamo in January, in the context of a defense motion to suppress evidence alleged to have been obtained under torture. That examination and cross-examination could well be available to the prosecution. Finally, on resources, I will only highlight that the statute requires compliance with the fundamental human right of non-discrimination. It's recalled that all of the individuals in the U.S. torture program were Muslim or perceived to be Muslim. Victims should not be denied justice because of their religion, national or ethnic origin, race or other status. And likewise, potential defendants should not escape liability because of theirs. It's important to note the factors the pretrial chamber did not include. First and foremost, there is no discussion on the object and purpose of the ICC and the Rome Statute system: to end impunity for grave crimes and thus to contribute to the prevention of such crimes. That is the purpose of this system. As I said yesterday and will repeat today, because there were questions raised, the United States has been wholly unwilling to hold any senior U.S. official accountable for the U.S. torture program. No one member of the CIA has been prosecuted for the serious crimes you heard about yesterday. And the United States has not taken up this chamber's invitation to appear in these proceedings and confirm its commitment to accountability. Moreover, the United States has often intervened in even civil lawsuits to try and block victims for redress, and as we learned a number of years ago through WikiLeaks cables, actively interfered with criminal investigations brought in other countries under universal jurisdiction. Quite simply, if the United States doesn't want to come before the ICC, it has two choices: prevent its citizens, and especially members of its military, intelligence services, and senior officials, from committing serious violations of international law on the territory of the 122 member states of the ICC. Or hold those citizens, including senior officials, accountable if such violations have occurred, and cease the harm to the victims, provide an apology, and redress. But the choice of factors was not the only error by the pretrial chamber. If the pretrial chamber was going to step into the role of the prosecutor and make a determination as to whether an investigation would not serve the interests of justice, which again, we submit was a legal error, then it should at least have to follow the weighing of gravity and victims' interests on the one side versus interests of justice on the other, as set forth in Article 53(1)(c). And in order to foreclose the investigation, conclude that its interest of justice factors, quote, nonetheless constitute, quote, substantial reasons to override victims' interests and the gravity of crimes. The pretrial chamber engaged in no such assessment. If it had, I submit the pretrial chamber's interest of justice factors would carry very little weight, and certainly not constitute substantial reasons to believe an investigation supported by the victims into U.S. torture would not serve justice. Yesterday, you heard in some detail the specific conduct to which victims of the U.S. torture program were subjected. Those facts were not presented for shock value, but rather to inform your honors about the gravity of the crimes. They also demonstrate that the torture program was not the product of a few bad apples or mere excesses by some soldiers. They constitute war crimes and crimes against humanity, which is what we put forward in our victims' representations. Had the pretrial chamber examined the gravity of the crimes without the legal error regarding nexus to the armed conflict, which colleagues will discuss, it would have concluded that the scale of the criminal activity in the situation, the length of time over which it occurred, the level of depravity employed, and the widespread and systematic manner in which this criminal enterprise was carried out warrants the attention of the investigation by the International Criminal Court. As the OPCV rightly explained yesterday, the pretrial chamber did not take victims' interest into its interest of justice assessment. Rather, in paragraph 96, it flipped victims' interests on their head, and again, inappropriately replaced the views of another group, here, the victims, with its own opinions. Thank you very much, Your Honors.